Well, hello, everybody. Whoops, I'm gonna grab the microphone. Hello, everybody. Welcome. Thank you for being here today. I appreciate the value of your time, and I hope that I'm able to impart some wisdom and maybe help you in your success, and hopefully take away some of your fears. I find it's interesting that people worry about disclosures. Now, I said, I don't know why you worry, just do them, right? Um, Pretty simple. So we are at the Greater San Diego Association of Realtors. Checking my other computer, make sure we're on live. This is being recorded. And just so you know, if you have questions, if you would put them into the Q&A field, because then I can answer them, but nobody else can see the questions. So when I sound like I'm reading something blanking off into space somewhere, I'm actually reading the question out loud, and so that everybody will know what the question is, and then and that's how it is. But nobody sees you, nobody hears you, no nothing. So it's kind of a safe thing. So please don't hesitate to tell me how you're doing. So again, we're at the Greater San Diego Association of Realtors, and my name is Kevin Burke, and there's my telephone number, and there's my email address, and I would really just as soon speak with you in person. So give me a call. I'm happy to help in any way that I can. I actually had a call from a former mayor of Del Mar last night. Interesting and funny how she even remembered who I was, but that was 20 years ago. So anyway, so that's just how it is. Call me anytime. If you can't get through, send me an email. You are not bothering me. Please be persistent. I do want to speak with you and I do want to help. Okay. So that being said, I do have some credentials, I guess, that make me qualified to speak about the subject matter today. So I have a broker's license in several states and getting another one here pretty soon. I've been in real estate for almost a half a century. And if you're newer, I applaud you for being here. Every day in my business, it's almost like it all started all over again. So I'm very excited about what I do, and hopefully, yeah, you will be the same. I do teach attorneys continuing education, MCLE approved classes on real property law. I'm in the middle of the class right now. Not this class, obviously, but a class at UCSD that goes on for another couple of weeks. And legal aspects of real estate's my thing. Risk management on the right-hand side, I was honored that the chair of the education committee called me yesterday and said, you are risk management. And it's interesting because the president of the California Association of Realtors said the same thing. I thanked him profusely for making me chair last year of realtor risk management, and he looked and he poked me in the chest and he says, you are risk management. So folks, listen, I want you to be okay. If I can help you, please let me know. Okay, it's very, very important. So we're probably going to be talking about stuff that's going to appear to be legal. I am not a practicing attorney. I want to make sure that's clear. I knew my last semester of law school, there was just no way I was going to practice law. So they work harder than we do. We make more money than they do. But I just knew I wasn't going to do it. So that being said, my trial work, I do a lot of trial work, is limited to testifying as an expert witness. And again, the Department of Real Estate says you may not call yourself an expert unless it's in a title. And so we see that in certified distressed property experts. Hi, Holly, welcome back. Holly's here to make sure that I have the camera on at the appropriate time. Really saved me this morning, Holly. Thank you so much. I'm talking to myself and the camera's looking at something else. Anyway, expert witness. So I am standard of care. Obviously, did the agent do what they were supposed to do? Would it have been something that should have been done by an agent? Agent's duties of inspection and disclosure, and then finally market conditions in San Diego County. Although I do work across the country on each of those subjects. So our conversation today is not intended as a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. Occasionally, somebody will ask me a question that I'll have to kick that back up to the broker. Just say, hey, you know what, you need to ask your broker about that. In most cases, we're talking about hypotheticals and theoreticals, and I can help you with those pretty easily. But obviously, I know at what point it needs to be talked about regarding your broker's policy of doing things. So our talk today is intended to be interactive. Please ask questions or offer input by utilizing the Q&A button. I do look forward to hearing from you. You helped me out, as Holly did this morning, helped me out significantly by keeping me on track and making sure that everybody could see. And Holly, you're on twice today, and that everybody could see what we were supposed to be seeing. Okay, so that being said, this morning we did maintaining records, reducing risk, and as always, this evening I will. It takes a little while. They've got to edit out the bad language and stuff like that, and so it takes a little bit. And then this evening I will load maintaining records, reducing risk, as well as all about disclosures, which is what we're going to talk about today, the 30,000 foot level, as we say. And Thursday morning, a real treat, the TDS, the SPQ, the SPQA, and the AVID. And we are going to just dissect those forms. Again, that tends to be one of my favorite classes. And if I'm going to get hauled into court, it's going to be because of an issue with one of those forms. So it's usually a failure to disclose issue. Okay, so just so you know about that. And then in the afternoon, we'll talk about disclosures, statutory versus contractual. What's the difference between the two? What rights are associated with one and not with the other? I have people tell me this, well, we can get out of the transaction for any reason for 17 days, and that is so not true. So if hopefully it's not your broker telling you that, but we do not have what we used to refer to as a free peak or anything like that. We gave that all up in October of 2002, actually. Here you got a little history going on, but in October of 2002, we changed the platform from sales were either by as is condition as of the closing, or that the seller would warranty that everything was working. And we also got rid of passive removal of contingencies and replaced it with active removal contingencies, which means you actually have to sign off on it. And oh, by the way, when you sign off, it's done. You don't get to come back to it. And so we'll be talking about those and the buyer's ability to cancel, whether it's a material fact or not, stuff like that. So again, fielding questions. If you have questions, do please let me know. So today, thank you for joining us. Member benefit, my member benefit screen is gone. Where did that go? So San Diego Association of Realtors member benefit, all about disclosures. And so I do want to say in the beginning of everything that California is really quite unique. It isn't caveat emptor. And so just so you know, and again, I teach this in Virginia, where I'm also a broker. I have a broker's license, and here in California, and they're completely bipolar from each other. So in California, it's not caveat emptor, which means buyer beware. Instead, it's caveat vendor, which means seller beware. And so why are these disclosures even required? And essentially they're required to protect the consumer. And in California, at least, other states don't feel quite that way. But we'll talk about that a little bit. So let's discuss some California appellate court cases. And so we got a couple of really good ones, and they're kind of the linchpin of everything that we do. So let's take a look. They changed the landscape, certainly, for California real estate licensees. And so the first one that I want to talk about is the Easton case. It's going to be Easton v. Strausberger. And so let's cue up Easton. I like that. I came up with a new thing now. We're going to talk about queuing things up. So where did it go, Kevin? Where did it go? Oh, here it is. Okay, sorry. So Easton case first, and of course I have so much. And by the way, I should say, everything that I talk about here today, I have a lot of handouts. I have a lot of material. If I was with you in person, then I would be happy to hand them to you physically in the room. But obviously, in this case, we aren't. And so I'm going to offer you any of this. You send me an email, I will send you the whole kit and caboodle, as we call it. So the entire file. More than happy to get that to you. So the Easton case, and this is going to be a synopsis. We're going to talk about Easton, and then we're going to talk about the Field case. Okay, and so Easton came out of LA. This is a decision made at the appellate court level. So whenever you see APP, this was made in 1984. And here are the plaintiffs and then the respondents. And and the one we're going to focus on today, we're not going to read the entire case. I mean, it's quite lengthy, but what I have highlighted it in advance. I spent a long time on this morning. It's an amazing case from where I'm coming from. I actually know some of the attorneys in the case. And so it was a court of appeal. It was a first appellate district decision. Got lots of letters after it. This was absolutely published, and this was done February the 22nd in 1984. So that being said, I didn't highlight anything up here because it really wasn't important, but some of the facts of the case, the respondent, that would be the buyer, of course, because remember, it's the buyer who sues, right? I mean, the buyer, it's usually the buyer who's unhappy about something. And so, and I say that in happiness because, seriously, folks, when, we worry about doing real estate transactions, we worry about litigation. The two people we're most worried about are going to be the lawyers and the Department of Real Estate. And I'm going to tell you not to worry about each. Take care of everybody, right? I was in a deposition, again, as an expert not that long ago, and the attorney asked me, she says, so how many times have you been a party to a lawsuit? And I had to think of it for a second. God, I'm in court all the time. And I realized I've never been a party to a lawsuit. Now, I don't knock on wood or anything like that. I just take care of people. And so if you take care, I find that a lot of times, and it not always the case, but the people that are just, downright nasty, or the people that don't return phone calls, that don't stick their head in the mouth of the lion, those are the ones that just tend to get involved in stuff like this, or make misrepresentations or things like that. So, and again, as I said, it's not all the time. I said, but a lot of times I just find that things can be taken care of. When I was management with the rock people back in the late 90s and early 2000s, my job was to keep things from getting to the attorney, the company's attorney. And I was pretty successful at that. I could usually, a lot of times it was really just a misunderstanding. And so I'm going to tell you, be thinking that way, okay, as we're looking at this case. So in this case, the buyer purchases a property for $170,000, from the Strasburgers, May of 76, by the way. So, 8 years later, we get the appellate court decision, which means you had to go through the superior court, you had to go through the lower court, win, lose, whatever, and then somebody's unhappy with the decision and they kick it up to the appellate level. And we're going to find, interestingly enough, that they were still unhappy with the decision at the appellate level, and they tried to go to the Supremes, and the Supremes denied. They said, no, we're not going to look at this because you guys, you did it right the first time. So let's take a look. 170 grand. Closed July. That's not really relevant, but the appellant was the listing broker. So the seller's broker in this case, okay, that's the person. That's going to be Valley of the Sun or Valley of California up here, Valley Realty. So right after they bought the place, there was a massive earth movement on the parcel, and it destroyed a section of the driveway, et cetera, et cetera. Again, I'll send this to you already highlighted. It's a famous case. Portion of the property was fill. And now, so there's a difference between cut and fill. So fill is where they bring ground in, they compact it to make it level, hopefully level, right? And it's compact, it has to be done properly, and then everything should be fine. Cut is where they just cut the ground or cut into a hillside or whatever, so that it's just, it's all solid, centuries of compacted soil kind of thing. Okay, so it had not been properly engineered and compacted, caused the foundation of the house to settle, which in turn caused cracks in the walls and warped the driveways. Okay, so again, they paid $170,000 for it. The estimate after the movement was that it was worth about $20,000, which is a significant reduction in or diminution in value, we call it. So cost for repair exceeded the cost they paid for the house, roughly at $213,000. So the agents conducted several inspections of the property. They were aware of red flags that should have indicated to them that there were problems. They did not request soil stability tests, nor did they inform the respondent that there were potential problems. Nor did they tell the respondents to have soil stability tests. Okay, so several issues in here. The minor slide in 73, now 73 would have been before they purchased the property, right? It was owned by Strasburgers. There was a minor slide, 10 to 12 feet of the slope. Major slide in 75. and it had a significant impact on the property. They did not tell the seller's agents about the slides or the corrective action that they had taken, and that's important. The seller's agents were not aware of the fact that the seller had had a problem earlier. Is everybody okay with that? Making sure it's on the screen. So therefore, the buyer purchased the property without knowing about any of this stuff. Okay, because the seller's agent. Now think about your transaction today. Do you know the property as well as the seller does? So we've talked about the fact that the seller has an obligation because they're in the best place to know the condition of the property, right? So what is the agent's responsibility? And that's the heart of the Easton case, okay? So big lawsuit. Again, the jury found that everybody had been negligent, all the named defendants had been negligent, and then they apportioned the what's called comparative negligence. Everybody gets, a piece of the problem. So scrolling down, I'm going to speed this up just a little bit. Where are the rest of my highlights? Oh, here we go. Okay, so in sum, again, this is the court at the appellate level saying that the duty of the real estate broker representing the seller to disclose facts includes the affirmative duty to conduct a reasonably competent and diligent inspection of the residential property listed for sale and to disclose to prospective purchasers all facts materially affecting the value or desirability of the property that such an investigation would reveal. Now, where have you heard that before, right? Your transfer disclosure statement, right? Your Avid. These are all things that came out of this lawsuit. 2079, California Civil Code 2079 was an attempt to codify the results of this case. In other words, we can't say, buyer, you're on your own. We're going to say the seller knew something about the property, and they essentially didn't say anything about it, and so they were negligent in telling the buyer about the problems of the property. Now, again, in the legal field, we get into intentional misrepresentation, we get into negligent misrepresentation. Those are not going to be our issues here today. But the issue here today is for sure that you have an affirmative duty, which means you must do, right, a reasonably competent, diligent inspection of the residential property. And by the way, visual came out of this as well, okay, reasonably competent, diligent visual inspection of the property, okay? And so again, we're looking for material facts materially affecting the value or desirability of the property. Now, any real estate attorney that I speak with, this rolls off the tongue. I mean, so we've coined a term in California, it's called the QCREA, and that is the Qualified California Real Estate Attorney, right? Because, I get the phone call from people. They call me on the phone and they say, well, my attorney said, and I go on, wow, that's really weird. I teach attorneys this stuff. So it's like, where's your attorney? I go, oh, well, they're in Illinois. And I go, but are they barred in California? Well, no. Did you tell them you were asking them a California question? And the answer, of course, is no. And because that attorney could be disbarred instantly for giving information, about something that's going on in a different state, much less California, where we just have more lawyers than anybody else has, right? So, this is really, really important. And so, let's not be quick to go to judgment on these things, but this is for sure, this is the Easton case is just, it was a game changer in a very big way. So a seller's broker, again, we're talking about the seller's broker again. Now, don't be thinking, well, I only represent buyers, so I'm okay. I don't know. We're going to wrap this one together here in a minute, but a seller's broker in a residential real estate transaction is, in italics, under a duty to disclose facts materially affecting the value or desirability of the property. You hear this recurring theme, which through reasonable diligence should be known to him. So in other words, the seller's broker was not informed about the repairs that were done to the property or the soil problems that the property experienced, but there were things about the property that should have led him to believe that something was wrong. It's kind of like when I tell you to disclose a leak, right? So you're in bedroom number 2, you look up, this was a case I had actually, where the agent looks up and he sees the stain in the ceiling, and he notes in his report, did a great job, he puts in water stain noted in northeast corner of bedroom number 2, right? So you did a great job up until you modified it, until you described it. Remember what I always say, we want to disclose, we don't want to diagnose. This is the pivotal part of our businesses, is that our job is to do that visual inspection of the property. Remember, the buyer does the investigation, the agent does an inspection, right? And then report what you have observed. And so we'll look at the AVID form, and we'll talk about that. In fact, before I get timed out on the AVID, let's go up into here. So here's our. I'm going to go to my templates. So here are the templates that I have created. And so among those, you'll see that I've got the seller listing, the buyer offer, all these things in here, disclosures, statutory or contractual, my TDS, SPQ. These are classes that I do. So these are things that I'm going to have a template in. And the reason for that is that I know my templates are always going to be current. So I'm going to go up here where it says disclosures, and I'm going to click on disclosures, and I'm looking in here and I see statutory disclosures, see contractual disclosures. So let's take a look in here. Let's take a look at some statutory disclosures. So first thing I want to look for again is going to be my my TDS, and here it is. And again, it is the most current version. And how do I know that? Because it says right up here at the top, 623, okay? So please make sure you're using the current version of the forms. Don't be using outdated forms, okay? Now if you're, unless we tell you otherwise, if you're in the middle of a transaction, when we change the forms, so for example, we changed the forms in what was it, June 27th of this year at 1:30 in the afternoon. I was so excited. I mean, hitting the refresh button, I was so excited for the new forms to come out, even though I do the classes on the new forms, but just seeing them was what I really needed to have, not the red line version. And so and stuff that you and I can fill out. Okay, so with the TDS, I'm going to fast forward down to page 3, because page 3 is our page. It's the one that we do anything with. 1 and 2 belongs to the seller. Okay, and page 3. Notice that we've managed to figure it out so that even the signature line in the newest edition keeps it on page 2. In several iterations of the TDS, we couldn't compress the signature line. The seller's signature was on page 3. We don't want that. We want, again, we're talking about disclosures. We want page 1 and 2 to belong to the seller. Okay, page 3 really belongs to the agents. Okay, so of the TDS, and by the way, statutory form, which means the legislative body created this. Okay, I don't know how else to tell you how important this is, but when I take a look at my paragraph number 3, which is the beginning of the agent's contribution to the disclosure, it says, based on a reasonably competent, diligent visual inspection of the accessible areas of the property in conjunction with that inquiry. So where have you heard this before? We just heard this in the Easton case. So out of the 1984 appellate decision, right? And I think, frankly, well written. I personally believe, again, I'm not a practicing attorney, but I just think it was a great case. Maybe the result wasn't great, but the idea was, and that was it took us away from, you're stuck, you're on your own, you figure it out, Mr. and Mrs. Buyer. Okay, so here I have this admonition here, and then I have it again down here under the buyer's agent. So essentially the same duty, right? Based on a reasonably competent, diligent visual inspection of the accessible areas of the property, right? So pretty much the same thing. Okay, and then we have the language, may wish to obtain professional advice. We don't rewrite that. Let the lawyers write that stuff. And in this case, let the legislative body write that stuff. But we don't write that stuff. And so I look at that, and then I look at my my AVID. Let me see if I can find it. Look at that, top of the queue. So then I look at my AVID, which is what I talked about earlier. And I'm going to tell you, I'm going to see the same thing again. Okay, so again, this is the most current version of the AVID. I'm going to tell you that this paragraph down here at the bottom, what this means to you. I have been in a trial with some brilliant real estate attorneys. Again, I'm pretty much always representing the defense, the brokerage, and a really big case that I had. What this means to you, and the buyer who was suing said, actually made the claim in court. And by the way, he was an attorney, made the claim in court that he thought that the seller's duty of disclosure and the agent's obligation to inspect the property satisfied his requirement to do an investigation of the property. Remember, 3 different duties. Seller discloses what they knew or should have known. Agent discloses, does a reasonably competent, diligent visual inspection of the accessible areas of the property, and the buyer's obligation is to investigate. And here, this is a real estate attorney who made this comment in court, and needless to say, it was a great case. It really was. It was expensive, millions of dollars on each side. But anyway, so the admonitions that are written in here, I'm going to tell you, you should always read these things. You know, folks, if you're newer in the business, read them at least once. Okay, go through them, make sure that at least you've read them, so that you're not making statements inconsistent with what is written in the form. The form is written is to level the field between the buyer and the seller, and I think we're at a point now better than we've ever been that it does that, but also to protect you as the real estate agent. So look at this. Here's top of page 2. Based on a reasonably competent, diligent visual inspection of reasonably and normally accessible areas of the property. It keeps on going. Okay, you're getting to a point you probably have that memorized by now, right? So then I get down to page 3 at the bottom, which is where we start signing things, and it says again, based on a reasonably competent, diligent visual inspection of reasonably and normally accessible areas. Folks, they're not trying to be funny. This is real. And so they're quoting Easton. Okay. So that's why we're looking at Easton and we're thinking, okay, I get it, right? I mean, this is critically important. Okay. So that being said, anybody have any questions about that so far? I'm going through my queue here. Robert, welcome back. Okay, good. Denise, thank you. You were here this morning too. Thank you, I think, right? All right, so Easton's a great case. Needless to say, let's fly through here because I've highlighted, like I said, the important parts. But because such agents are expected to make use of their superior knowledge. Oh, all of a sudden you have superior knowledge, right? I always say, you know, that at no time do I ever hear the real estate agent spoken so highly of. You know, their qualifications, they're so professional, all that, except in a court of law, right? And why? Because they're trying to make a case for the fact you're the professional and you deceive the buyer, right? Which, you know, a lot of times is not the case, but okay. So such agents are expected to make use of their superior knowledge and skills, which is the reason they are engaged. This is why you hired a real estate agent. And again, we're on Easton, and because the agents in this case were or should have been alert to the signs of soils problems earlier. Now, are you a soils expert? Probably not. But if you see a depression in the ground, maybe you should be thinking that needs further investigation, right? Okay, so the jury was well within bounds, blah, 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 blah. That a reasonably diligent and competent inspection of the property would have included something more than a casual visual inspection. So again, you know, up until the Easton case, you know, we just wandered through real estate transactions and we saw something, maybe we said something. You know, by the way, it's the antithesis of this in Virginia. In Virginia, you keep your mouth shut. You don't tell anybody about anything. I did a real estate transaction recently in northern San Diego where the buyer's agent had a license in Virginia for a very long period of time, and now was doing her first transaction. Lucky you got me. She, at the end of the transaction, said, "I have never seen anything like it. This is like the opposite of Virginia." So, folks, I'm going to tell you, everybody that does a transaction with me always comes out saying, "I learned so much," right? And so I feel like I learn in every transaction that I do. So, you know, I have to be fairly thorough about how I'm going to do my job. But again, lots of court cases that they're citing, and then appellants agents. So were aware of the fill on the property. The seller's agents were aware of the fill on the property, and that erosion and settlement problems are frequently associated with such soil. Uneven floor of the property. Have you ever walked through a floor? I remember walking through a floor in Del Mar on an oceanfront property, and I swear it would not pass the manometer test, right? You drop a marble anywhere on that floor, and it would pick up, it would accelerate in another direction, right? So, and the use of netting to repair an earlier slide. So you saw all these things. Now, later on, we have court cases that say, you know, things that are outside that the buyer wouldn't have otherwise seen. So essentially a latent defect or something like that. I don't know. The netting might have given everybody a clue, including the buyer, but you know, we needed to get to the result that we got to in this case. So flying through here, and again, I'll send all this to you. They talk about the American motorcycle case, actually a very interesting case. So so this is where I thought I'd throw that in there. The appellant's petition, yeah, I can talk. The appellant's petition for a hearing by the Supremes was denied. That is really upsetting, right? So think about it this way. You had Superior Court. You probably had millions of dollars into paying attorneys and all these things that are going on. You lose. Then you go to the appellate court thinking, you know, that was just a dumb result. You know, we're going to fight this at the appellate level. You'll lose again, right? And then you try to go to the Supremes, and the Supremes go, we don't want to hear anything about it, right? You know, we thought that the lower courts did the job right, and by the time you get to there, so at the lower court you prove your case. At the middle court, the appellate court, you don't retry the case. What you do is you look for errors of law and things like that. And so by the time you get to the Supreme Court, there's really not a whole lot left. You've done everything you can do, but we got money and we're going to do it. So I wrote a couple of other little notes. So despite the absence of privity, we call it privy of contract, but privity of contract, a real estate agent is clearly under a duty to exercise reasonable care to protect those persons whom the agent is attempting to induce now, like you're a bad person, in entering a real estate transaction for the purpose of earning a commission, which of course this is what we do, right? I mean, just bad. Why are you trying to earn a commission? Well, we work, right? I mean, that's what we do. And so, but you know what, folks, we're going to be held to that standard. It's the single largest purchase of a lifetime for these people. And so we've got to know what we're doing. And I don't think it's that complicated. I think we make it complicated. I think we really do, but you got to know your stuff. And again, I didn't get to where I am today knowing I know 2 or 3 things about real estate. I didn't get there overnight. It was something that I learned as I went along. And so read the right books, do the right material, and I will help you. If you send me an email and just ask me, where do I go for this? Where do I go for that? I am happy to help you. Okay. So your job is to protect your client. So despite the absence of privity of contracts, in other words, there was no privy of contract, you're clearly still had the duty to exercise reasonable care. Okay. All right. And reasonable, by the way, is a term of law, the reasonable man standard, which I'm sure California has changed that by now. But the reasonable man standard said what the reasonable man would think or would do. Of course, that's usually what a judge thinks or what the judge is going to do. So let's see, another little note. In the typical residential real estate transaction, the buyer may be intentionally or inadvertently led under such circumstances to believe the broker will represent their interest. Now, here's what happened. And we're going to see this again in a field case in a minute, but even when he's aware the broker has a listing agreement with the seller. So the buyer is supposedly trusting the seller's agent, even though he knows that contractually the seller's agent represents the seller and not the buyer. Since the broker's commission is generally paid as a percentage of sales price, here we go, right? You're going to be leading. Now, this case, believe it or not, is going to lead us to where we are today with buyer representation agreements. And I know everybody's been telling you, if you're new in the business, oh, wow, no, I'd never sign one of those. I'm going to tell you this, mark my words, it's here, and it's going to be, and it may end up being statutorily required probably in 2024. Okay. So, there's a lot of talk about this right now and from all levels. In other states, by the way, they require it. In fact, in Virginia, it became a law July 1st that you must have a buyer representation agreement with a buyer. And I really do think that that's going to take hold in California. And my hat is off to the committee, the task force that created the new buyer representation agreement, because they just did an amazing job in California. And the chair of that committee or that task force was the same person that helped us get rid of that wood destroying pestidenum that pesky wood destroying pestidenum from so long ago. So since the broker's commission is generally paid as a percentage of the sales price, oh really? Okay, the broker's interest is more closely identified with that of the seller than of the buyer. All right, so this is what we call dicta. This wasn't the holding of the court. This is just some of the language that we see in it, and we're going to see how it's very damning to us in the field case in a minute, where the buyer is unappreciative of the potentially divided loyalty of the broker. In other words, they don't get it that the seller's broker is in it with the seller. He may be lulled into relying on the broker to his significant detriment. Right, but remember, they were represented too. Okay, misplaced reliance by the buyer can extend beyond the issue of price to questions regarding quality of title, condition, et cetera, et cetera, et cetera. So remember, again, they were represented by an agent as well. And so, what happened to that, right? So effectively unrepresented because of the problems of dual agency, which is a real problem, by the way. I can tell you that in the legal field, attorneys don't understand how we get away with dual agency, because how can you possibly represent both sides of a transaction? It's like representing a husband and wife in a marital restructuring, as I call it. It's almost impossible to be able to do that effectively. And they were talking about purchaser of commercial real estate, is usually going to be more experienced and sophisticated, and usually represented by an agent who represents only their interests. Buyer representation agreement, only their interest. Okay. All right. So without beating that to death, that's pretty much everything on the Easton case. So let's go back in and let's take a look at. Let's talk about the Field case. And the Field case, I really enjoy the Field case, although it didn't bode well for us as an industry. So let's take a look at the Field case. So queue up Field, as I say. I'm going to go ahead and click on. Whoops, where did it go? Where are we? Easton. There's Easton. So let's talk about Field. So Field is a case that came right out of our backyard. I always say the best lawsuits are always out of Southern California. Okay, so the Field case came out of the Otay Mesa Water District. It was a statute of limitations case, strangely enough. But again, the dicta, the language that the judge used in their opinion, not their opinion, but the language that they used, it was really not good for us. So again, this is also going to be an appellate court decision. This is the 4th Appellate District Court of Appeal. And this case came down in 1998, which was 14 years after the Easton case came down. But we're going to see a lot of quotes by this court on the from the Easton decision. Okay, so this was partially certified for publication. We actually fought. This is back in 1998. We actually fought not to have this published because when they publish a case, it becomes the law of the land. Again, you're at the appellate level. Chances of it going up another rung are pretty small. The chances of a change are also remotely small. But if they publish it, it's the law of the land. If we could have kept it from being published, we would have been in a lot better shape. Okay, all right. But it just is what it is. We have to deal with it. And again, so let's take a look. I put a couple highlights in here. They're going to hold that the 2-year statute of limitations. And again, remember what I said. This is a statute of limitations case. This is not this case shouldn't have. I don't think it. Again, I'm just a nobody, but I'm thinking that they probably shouldn't have written what they wrote about the case. But it is a statute of limitations case, and the whole issue was really, Civil Code 2079, and we're going to see they're going to quote, Easton creating 2079, but 2-year statute of limitations does not apply to claims for a breach of fiduciary duty. In other words, you have a 2-year statute of limitations for some things, but not for breach of fiduciary duty. So against the brokers by purchasers whom they exclusively represent. So Century 21 does not claim the evidence of breach is insufficient, right? But challenges the court's failure to find that the action was time barred. The Century 21 Cloud and Finesse, big company, by the way. I mean, it was not a slacker in our business at all. Big company. The players in that company are excellent agents. It just a mistake. It was something that happened in the case that shouldn't have happened. And so let's take a look at that. Again, I think Shirley is actually still practicing, but that doesn't mean anything. It just means that it was she was it was just one of those things that she got tagged on it. That's all. The fiduciary duty, fiduciary in italics, of a broker who contracts to exclusively represent a purchaser of real property to investigate for its client is independent of the separate obligation imposed on a seller's broker to conduct a reasonable visual inspection of the marketed property. Remember that they couldn't even quote the Easton case very well, right? We've already got Easton down. For buyer's protection as announced in Easton v. Strasburger, okay? And incorporated into California Civil Code 2079. Okay. The beautiful part, I'm going to show you 2079 in just a second. You're going to be shocked that you've had it in front of you the whole time. Okay. So it was a rural residence. It was out in the middle of nowhere. Century 21's failure to inspect related title documents and to determine the scope of an easement in favor of the water district. Defendants falsely represented Otay had an easement only for the use of the driveway. It was obvious the agent, didn't know. Again, negligent misrepresentation. She didn't know. She thought the easement was much smaller than it really was, and they relied on that information. And apparently rightfully so, although in fact the easement prevented the Fields from exclusively using a major portion of their property. Why? And we're going to see in a second, because the easement was more extensive, more intrusive, covered more area, included the right to spill water onto the Fields' land, including some area occupied by the residents. So we're going to flood the house. Okay, so acreage was less than represented. That was the other issue in the case. Again, I always say that good fences make good neighbors, but they make lousy property boundaries. Remember that the people that install your fence are not surveyors in most cases. The people that install the fence are people that install fences, right? I mean, they're not going to be surveyors. They're not going to understand, what it is that they're being asked to do. They say put the fence along here, and that's it. And so I see this Carmel Valley, for example, their property that are like 3 and 6 feet off from center where they should be. And again, I don't even know if that was the fence people's part. It was just they put the fence where they were told to put the fence. Okay, so be careful about that. I've got a number of these. I had one case where the seller's agent said to the buyer in the presence of the buyer's agent, the buyer says, how far back does the property go? And the seller's agent said it goes back to that fence. By the way, the seller's agent lived next door, and in that same case, they represented that the property was on sewer when in fact it was on septic. So there's all kinds of bad things going on. Anyway, needless to say, it goes to the fence. And then, of course, immediately after closing, the neighbor, there were 2 other neighbors before you got to the fence. And the neighbor in the middle erects a fence to essentially create a division that now the buyer is saying, well, wait a minute, we own that property all the way to the far fence. And it's like, no, I own this one. Okay, it happened to be owned by a real estate agent, by the way. So it is what it is. So let's see. So buyer's agent was aware an easement existed, but neither verified the extent of the easement or represented acreage of the property, nor did they advise the fields to do so. So they didn't say, hey, you need to check out that easement. So when I talk about my how to read a preliminary title report, the class that I do on the prelim, it's very, very well received. And I always tell people, you have title to give you a property profile, sold comps, any recorded documents, and I want them to blow up the map so that I can read it, and I want them to plot and color code the easements. So they will do that as a matter of fact. It's very easy for them to do. They don't charge extra for that, but a lot of people don't even know to ask for that. So property profile, sold comps, any recorded documents. I'm looking for NODs and things. Blow up the map, plot and color code the easements. It's a script. I ask for it every single time in every transaction that I do. And nowadays they're getting better and better to have just clickable links in the prelim so that you can click on it and pull it up yourself. Okay. All right. So, but in this case, the agent did not verify any of the information and did not tell them that they needed to verify the information. So conduct implied, the agent implied both the acreage and the extent of the easement were as erroneously represented. In other words, she said, no, this is it. This is how it is. So again, she didn't know. So negligent misrepresentation. If you don't know something for a fact, don't say it. And if you don't know, don't make it up. Right? I mean, you need to protect yourself and you need to protect your client. In this case, she was not protecting her client. Okay. All right. So in addition to that, the house violated setback requirements, which meant it was too close to the road. Okay. And nobody checked on that. Nobody told them to check on that. They did not recommend inspection of the septic system for code compliance. There was all kinds of problems with that, or alert the buyers to signs of obvious physical defects. So not only did they not inspect, this is the clincher here, not only did they not inspect the prelim in a timely manner, they didn't even receive it from the title company until after escrow had closed. Now, today we drill it into you. Go over the prelim with the client, again, field case, okay? Go over it with your client, but in this case, they didn't even have the prelim. So transaction close. Imagine the buyer closes the transaction, gets the prelim, reads the prelim, and it says, oh, by the way, Otay Mesa Water District, that big water tower you see up on that hill over there, they can at any point dump the bilges, Navy talk, right? Dump the water. It'll flood your property. It will also flood the house. So how would you like to buy that house? Okay. All right. So buyer's representative had breached her fiduciary relationship with the fields by not reviewing the prelim before close of escrow to verify, among other things, the scope of the easement revealed in the transfer disclosure statement. Now, you and I, we talk about this all the time. We want to limit our duty to our skill set. So, where did this come from? I mean, you talk to a lot of attorneys and they'll say this is bad law. I really can't opine on that because I don't give legal advice, right? But this case was kind of rough for us, right? Essentially, it said, no, you don't pull permits, you don't do stuff like that. but you should go over the prelim with your client. So as a matter of practice, Linda's company, my broker Linda, she has the parties sign off on the prelim, just a signature or initial on page 1, so that we can say that they saw it, and then hopefully that we've gone over it with them in case there was a question. I had a trial recently where the agent's defense was that they had gotten all the disclosures from the seller's agent. They gave everything to their TC. I always love it when somebody says, send everything to my TC. And I always tell them, I say, I'm going to send everything to you. I will copy your TC at your request. So if you want your TC to get stuff, I'm never going to send it only to your TC. You're the captain of the ship. I'm always going to send it to you, but I will copy your TC as an accommodation. Okay. So I will do that. Right. But here was this case. This agent said, well, I gave everything to the TC, and then they were supposed to send it over to the buyer for signatures and initials. And so they were asked, so what did you tell the buyer about the disclosures? And the agent's response was, I told them that if they had any questions to call me. And so that is a really, really poor defense. Okay. I mean, you're supposed to be going over these things with people. This is what your license says. Okay. But disclosures like, oh my gosh, there's a death on the property, right? Civil Code 1710. And it's like, did you bring it to the buyer's attention? Well, they had the document, then they signed off on it. So they must have read it, right? No, it's not going to work. It's not going to work for you. Okay. So the agent did not recall asking anybody about the easement, did not explain the fields could have a title company come out and mark the easement. They'll do a rough survey. They won't do a survey. Did not recall verifying the acreage information presented in the MLS, and did not recall checking the prelim for acreage information. So they didn't know how to read a prelim. All right. And so again, this is that language in here that's not very good for us. Okay. So you could have consulted with a title officer. I call TOs all the time, right? I like calling TOs. They like hearing from me, right? Because we have educated conversations, and otherwise they just sit in their title plant, just plinking away doing stuff, but then finally somebody calls them up and says, hey, I got a question, right? And so they get very excited about that. They have a whole bunch of people that answer your question. So I just closed a transaction up in Malibu on what we call a piece of dirt. It was a piece of land up in Malibu above the town up on the hillside. And so, I'm getting information from the title company. My buyer was amazing, was able to get a lot of information that otherwise other agents, I know they would never do it, but they were really, really good. And they had created little PowerPoints and stuff like that about what they were going to do. Everybody was telling them you can't do anything with the land, but they found out that you can do something with the land. And it was just that tenacity that I really admire. They did a really good job on that. So did not explain and plot the easement, failed to negotiate or failed to investigate the status of permits for the room addition, and did not advise the buyer to do that. Okay, so it's like, oh, this is just not going well. So section 2079, again, 2079 is our you'll know here. Let me show you. I want to show you section 2079. So here it is. Here is the agency disclosure. So essentially, this is Civil Code 2079. This is what the public facing part of it is. Okay, so this is 2079. By the way, is what holds us liable. So we are responsible for 2079. It is the realm of the real estate agent. And so again, remember, it came from the Easton case. It should, right? But, have you read this? I always ask that question because I think this makes great reading. I was actually asked to proof this, and it goes back 25, 30 years now, to proof the document. And you know what? If I go to page 2, and this is the front face, by the way, is very different than it used to be. Here's page 2. You want to understand 2079. This is what you read, right? Or you can go pull up the civil case or the civil code and read it, directly out of the code. But all we've done is taken a picture of it and put it on our letterhead. Okay, so this is a very thorough. This is very thorough. Again, 2079.13, 0.14, 0.15, 0.16. 7, 8, 9, on and on and on. And so this makes really good reading. It is bullet point about our obligation as agents on behalf of the principal, the buyer or the seller. I did find one mistake and again, it goes back to the word agents. It was spelled agnets. So back then, 25 years ago, people weren't so keen on, spell check and stuff like that. But it was the only mistake I could find. And I wasn't just looking for spelling. I was looking for grammar. I was looking for, that it was done right. It was a pretty good snapshot of the Civil Code. Okay, so does everybody understand that? Again, this is Civil Code 2079. And so certainly one of my favorite things, and certainly one of the things that I do a lot of trial work on. Okay, so back to the field case, 2079 requires sellers, real estate brokers, and their cooperating brokers, so buyers brokers, to conduct a reasonably competent, diligent visual inspection of the property and to disclose all material facts such an investigation would reveal to a prospective buyer. Okay, it establishes a statute of limitation for breaches of those duties that are imposed by 2079 of 2 years from the date of possession of the property. Okay, not from closing, date of possession. Okay, it was enacted to codify and focus the holding in Easton. The court recognized that case law imposed a duty on sellers brokers. Italics are put in there by the court. Sellers brokers to disclose material facts actually known to the broker. Later on, we find out that we have to be aware of clues. Okay, so knowledge that they should have known. So the case held that the seller's brokers are chargeable with what they so interestingly enough, the seller's standard is going to be knew or should have known, but in this case, we're going to say that there are some things that the agents should have known. So in other words, the netting on the side of the hill, other floors weren't even, you could roll a marble down, that kind of thing. So the statute 2079 statutorily limits the duty of inspection in Easton to one requiring only a visual inspection, right? The scheme expressly states the selling broker has no obligation to purchasers to investigate public records or permits pertaining to title or use of the property. Oof, one for us, right? Does not include or involve an inspection of areas that are reasonably normally inaccessible to such inspections. I had an attorney ask me the other day, so was there an obligation, of the buyer's agent to, unlock doors, open cabinets, things like that? And I said, it's a very limited duty to do all those things. And so if it's inaccessible, you don't have to go to heroic efforts. You don't have to kick doors down, do stuff like that. But I would definitely make a note in your avid that you were unable to access the subject room or cabinetry or whatever, nor an affirmative inspection of areas off-site. So that would include common areas and homeowner associations, or public records or permits concerning the title or use of the property. Okay, so there it goes again. We got another good one. Okay, so it is not the intent of the legislator to modify or restrict existing duties owed by real estate licensees. I like that because they said we're not trying to take the load off of the real estate agent. There are other rules that apply to the real estate community. So the statute of limitations for actions involving a fiduciary obligation is normally triggered on the date that the plaintiff discovers or should have discovered the negligence. So if we're talking about fraud, then it's going to be 3 years from the date of discovery. They have to bring their action. Okay. All right. Fiduciary duty, highest good faith, undivided service and loyalty. The broker as a fiduciary to learn the material facts that may affect the principal's decision. So I'm going to tell you something. We have a form called the BMI form. That's the buyer material issue form. And for those of you that haven't been in on hi Stephanie, haven't been in on my webinars before, it's almost always a good idea to have a writing instrument or some way that you can take notes, because I throw these things at you and then I hope that it helps you. But I got to move on. So the BMI form is the buyer material issue form. It is incident to the buyer representation agreement. And on that form, the buyer has an affirmative duty to tell the agent what is important to them in their decision to purchase property. Okay, so they have an affirmative duty to do that. If you don't use the form, then you don't have the protection, right? So because then it's going to be a he said, she said. The buyer says, well, I told you that I wanted my kids to go to this school, and you're like, we never talked about that. Okay, but if I'd had that BMI form and they filled it out and maybe omitted information about the school, now I'm going to use that form as exhibit A in my defense. Okay, you didn't tell me about it on the form, and you had an affirmative duty to tell me what was important to you. So the facts that a broker must learn and the advice and counsel required of the broker depends on the facts of each transaction, of course, right? So it's everything's going to be different. The knowledge and experience of the principal, the questions asked by the principal, and the nature of the property and the terms of sale. So the broker must place themselves in the position of the principal again, put themselves in their shoes and ask the type of information required for the principal to make a well-informed decision. This obligation requires investigation of facts not known to the agent and disclosure of all material facts that might reasonably be discovered. So again, all of a sudden, it sounds like we're being held to a higher standard than what we've always been told, which is, see no evil, hear no evil, speak no evil. Okay, so legislator has explicitly stated his statutory scheme was not to restrict the existing duties owed by real estate licensees. Nothing in this article relieves again, 2079.5 now relieves a buyer or prospective buyer the duty to exercise reasonable care to protect themselves, including those facts which are known to or within the diligent attention and observation of the buyer or the prospective buyer. So we're dancing all around the subject, but we're still going to hold the agents liable for this. Again, remember, the real case was a statute of limitations case. But when you read this language, you're going like, what's this got to do with statute of limitations, right? And so this is part of the problem that we see in this case. But again, it's the law of the land, right? A principal may rely on the buyer's agent's investigation, his fiduciary's investigation. So in this case, the agent represented that the facts were true and that in fact the property was of a larger area than it was purported to be. The acreage was not accurate. The easement was represented to be more minor than it actually was. It was a much bigger issue. All those kinds of things. So again, the buyer reasonably relied on what their agent told them because they held their agent out to be a professional. At the same time, the agent wasn't really doing anything to confirm any of this information. Okay, so no duty to investigate. In other words, if the agent told you something, then the buyer doesn't have a duty necessarily to investigate further because they should be able to rely on what their agent said, even though their agent was really making it up and puffing it. Okay, at least that's what it appears from the dicta. Okay, all right. Flying right down here. I think that was everything. Yes, that's it. So that's the Easton case. That's a doozy. Okay, but boy, we covered a lot of material when we talked about this case just now. And so I'm going to go ahead and close that one, and I'm going to take us back over to the PowerPoint. Whoops, there we are. We're back into the template. Let's go back over to the PowerPoint. There we go. Okay, so these were landmark California appellate court cases, changed the way that California does the real estate business. We're going to distinguish between the disclosures required of the seller and the disclosures required of the real estate agent. Let's talk about two main types of disclosures. So we're going to talk about statutory disclosures. And again, I'm not going to go into really deep detail here, but we're going to cover more of this on Thursday afternoon. But the second one is going to be my contractual disclosures. So those are my two big disclosures in a real estate transaction. So what's the difference between the two? Statutory disclosure is one that's required by California law. It's just the way that it is. Okay, anywhere in the country, any statutory disclosure just means there's a law in that state that requires it. Okay, so it contains rescission rights, and this is important. Failure to make a excuse me, we're going to discuss rescission rights in a minute. Failure to make a statutory disclosure may give an offended party, somebody that didn't get the disclosure, a right to reset the contract. Okay, so in other words, put the parties back in the position that they were in prior to contract. Okay, and then this is really important. So if you think about it for a second, this is one of the reasons I always tell you that if you're a seller's agent, that you need to be getting all the disclosures signed by the seller at the time of the listing, right? Because when the buyer's offer comes in, you need to be able to send that entire package over to the buyer's agent and say, here's the counter offer, here are all the disclosures. The buyer, you're not going to give them legal advice, obviously, but the buyer loses their right to rescind the contract if they have all the disclosures. It said that on the bottom of page 3 of the TDS, right? When we looked at the TDS, we were looking at, let me see here, let me pull it up really fast because it's a really important point. But at the bottom of the TDS on page 3, it says right here, it says 1102.3, one of my favorite civil codes, provides a buyer with a right to rescind a purchase contract for at least 3 days after delivery of this disclosure if delivery occurs after the signing of an offer to purchase. So afterwards, so prior to them accepting the counteroffer, they've got all the disclosures. It was delivered. You can say it was delivered. They don't get 3 days to review. It's done. When you buy the house, you have bought it subject to those disclosures. Okay, so if you want to rescind, you've got to act within the prescribed period, which means don't sign the contract. Okay, so in other words, you got 3 days if I give it to you after the contract, but if I give it to you prior to accepting the contract, you lose your right of rescission. And this is one of the reasons that I tell you, yep, it's on the screen. This is one of the reasons I tell you to get, as a seller's agent, get all the, listen, that's one of your best selling tools to the seller is say, hey, we're going to sit down, we're going to go over all the disclosures, and you're going to be, you're going to have a complete package when the buyer comes in. And so the house I sold in Lake Forest, I know I've talked about it before, but not all of you were here when I was talking about it, but seller completed everything. Buyer's offer comes in. I'm the seller's agent. Buyer's offer comes in, and all the disclosures go over to the buyer's agent. Buyer's agent says, my God, I've never seen anything like it. I mean, there's like 88 pages of disclosures. And I said, no, that was just the NHD. So we had done everything, right? We got the HOA docs. We had everything, property, NHD, the whole thing. And so, and you know what the buyer's response was? Well, we had a 30-day escrow, but I don't need it because you've told me pretty much everything. So, let's close it in 13 days. So I'm buying the RV. I got the boat coming, the whole thing. So again, if we don't give it to them, then at whatever point, you're going to have to give it to them at some point. It's a statutory requirement. The law requires that these things be given to the buyer. And so your question is this: do I want them going into the contract knowing everything that the seller knows about the property, or do I want to piecemeal it to the buyer later and give them the option of, unfortunately, sometimes buyers use it to renegotiate the contract, right? And so we don't really want that to happen, but what they do, right? Or worse yet, they can get out of the transaction. Now, woe behold, if the seller says to you, how can the buyer get out of this transaction? I thought we had an ironclad contract. I love it when agents say that. But the answer is, what? We left them out. And so are you going to fall on your sword and tell the seller it's because you didn't get the disclosures to the buyer in time? That may be the position. So this has huge repercussions in a real estate transaction in California. Statutory disclosures are easy to define. So we're going to talk about a couple of them just really quick, and some of them we've already talked about. Any questions so far? That's my excuse to get a drink of water. Okay, so some examples, anything with Cal Civ code in front of it, okay? So for example, Cal Civ code 1102, that's my TDS, right? Seller's duties of disclosure. And there's a lot of things inside of 1102, like 1102.19 is my fire hardening, so it's tied to the TDS, the three-day right of rescission. Okay, so so as an example, my transfer disclosure statement happens to be Civil Code 1102.3. I love 1102.3. It gives me lots of stuff to think about. Okay, how about my 1103.7? You don't have to remember the statutes. You just have to remember the fact that if it's got Cal Civ code in front of it, it's an important thing. Okay, all right. So 1103.7 is my NHD law that came about in 1998. I remember when it came about. Scott, I think you actually you had your license by that point, or maybe shortly after that. But I remember when the law came out, and I remember that the original form had on the main page that said, the seller signs it, the seller's agent signs it. Well, where the seller's agent signed it, it actually said that the seller's agent has certified that the information provided by the seller is correct. Well, remember, this was a statutorily created form. The legislative body put that together. We went crazy. We're like, we can't say that. We can't sign off on that. They required us to sign off. It took us 6 months to convince them they needed to change that word of certify to a different word that wasn't quite so impactful. Okay, so like represents, whatever. I think it's gone through 2 different iterations since then. But just remember, anything that's got Cal Civ code in front of it, it's a big deal. Anything with business and professions code in front of it. All right, so like Cal Biz and Prof Code 10177, broker's duty to supervise. Okay, failure to disclose licensee's interest in a property. So anything with Cal Business and Professions Code in front of it, that's going to be very, very important. So I talk about the East and the West Coast have different approaches to the issue. Okay, so in California, of course, everything must be disclosed, right? Everything. I don't care what it is. You've got to disclose everything. On the East Coast, some states prepare the disclosures for the seller. So again, I'm a broker in Virginia. I have a broker's license in Virginia, and there everybody is taught not to say anything so that you wouldn't incriminate yourself, even if you're aware. So, for example, death on the property is not required. You don't have to disclose the death on the property, whereas in California you do. Civil Code 1710. Okay, Cal Civ Code 1710 says you must disclose the death and the manner of death if asked. Right, and no obligation to respond if the deceased died of AIDS or HIV related illness. So obviously when you say, I don't have to tell you, then they know what they died of. Okay. So, all right. So, I'm aware of a property in Virginia right around the corner from my daughter's house where the one of the son of the owner had come back, killed the wife, kills the kids, which is such a tragedy, kills himself. So multiple homicide, suicide in the property, and no obligation. Property sold. It was in the newspapers, everything. Property sold. The disclosure was never made because I guess in other states they don't feel the necessity to disclose the death on the property. So again, this is clearly on the property. So why are they required? So of the seller, to assure that those with the most knowledge of the property share that information with the buyer. For the agent, to assure that the real estate professional, again, in 10-point letter up at the top, does their due diligence in the real estate transaction. Okay, so some of these even have the potential of costing a licensee their license. And so we don't want that to happen to you. So let's take a look at some statutory disclosures that are required by our purchase agreement. And so we're going to queue up the statutory disclosures. So let's pull some of these things up here. And I want to show you a neat little trick. So we're going to go back into my program here. So going back here. So notice again, what I've done is I've labeled statutory disclosures versus contractual disclosures. So let's take a look at some of the statutory disclosures, and we're going to look at these one at a time. But my agent's visual inspection disclosure, which we've already talked about, right? So we also have the California Consumer Privacy Act advisory. A lot of people blow that off because there's all a place for the buyer to sign it. That's it. But they don't realize how important it is. It was just updated again this year. And so we put the most current version in our forms. My agency disclosure, as I said earlier, no change to that for decades. And then CAR got together and said, hey, we need to change the language. So in October of 18, they changed the agency disclosure for the first time, but then they changed it again in December of 21 to match what they were saying in the actual purchase contract. And trying to make it so that things were written in plain English. And as I always say, I call it the Queen's English. And then Linda corrects me and says, it's not the Queen's English. She goes and looks it up, right? When I say something, she looks it up. So we have some other big ones in here: fire hardening, defensible space, lead-based paint, and lead-based paint hazards. We're going to come back to some of these things. I'll pull these back up here. But we have some other, like for example, Megan's Law database disclosures. So we have a form for that, which we've also updated, but it's already included in your purchase agreement. Okay, so the requirement is on you, and it comes from Civil Code 2079, and it says that you must disclose the existence of the database. I'm going to tell you never to go to the database, right? Because then you'll be held to have constructive knowledge of everything in the database. So if you go to the database, later on, I can just hear it in deposition. Why didn't you tell the buyer that there was a registered sex offender living next door? And the agent says, I didn't know that there was a registered sex offender living next door. And then the attorney says, when's the last time you went to the database? And you say, well, I went there, 6 months ago. And then the attorney says, well, they were on the database 6 months ago. Why didn't you tell the buyer that there was a registered sex offender living next door? Do you see how this is going to just not go well? So your obligation at law is to disclose the existence of the database. That is accomplished in the purchase agreement between the parties in the pre-printed language, and that's it. No obligation otherwise to do that. Okay. So TDS, MHTDS, exempt seller disclosure. I've had 2 cases recently where the buyer's broker was convinced that the seller was TDS exempt. Again, remember, if they're TDS exempt, that doesn't mean that they don't have to disclose what they knew or should have known. It just means they don't have to use the form. Okay, so let's pull that one up here really quick. I just want to show you really fast what it looks like. So this is the exempt seller disclosure. Remember that if you tell the seller that the seller is TDS exempt, you are clearly giving them legal advice. So, there's a lot of problems with that. In fact, I've got one I'm going to kick up to the department on this, where the broker insisted that they were exempt, and yet the seller met with the buyer inadvertently at one point, and they got along great, and the seller was giving them all this stuff that they knew about the property, but that the agent never had them codify that, never had them put it in writing. So this is my exempt seller. So remember, you still have, even though the seller might be TDS exempt, that just means they don't have to use the form, but they still have to make the disclosures. And so look at some of these. So within the last 3 years, death of an occupant of the property upon the property, kind of like Heaven's Gate. Think about Heaven's Gate for a second. So 40 people off themselves on the property. And so, is there an obligation by the seller to disclose the death on the property? Clearly, not just the death in bedroom number 2, but the death on the property. So even if one person died in the very corner of the property, it's still on the property. It's not in the house. Doesn't matter. The property means the property. It doesn't mean the structure. Okay, so really important. Now, I always argue that technically people can't die on a property because the EMTs that show up to pick up the body are not qualified to diagnose death, right? They have to take the individual, the deceased, back to the hospital where the doctor is authorized to note the death. So technically speaking, now don't hang on to that, because I don't want you to be thinking you don't have a duty to disclose a death on a property. If somebody died on the property, then listen, you need to err on the side of caution and make the disclosure, have the seller make the disclosure. Okay, so the rest of this stuff, I always love pulling up ordinance. So, ordinance is very different than ordinance. Ordinance with an I in there is a rule or a regulation, usually a local ordinance. But ordinance with no I in there is stuff that goes boom. So there is a misspelling in one of our forms. I remember seeing it, and I got to start writing these things down when I see them, because some of them for me are pretty comical, like the solar systems that we sell in paragraph number 11, 11M of the purchase of the purchase agreement. We were supposed to change that to solar power systems, but we didn't. So as far as I'm concerned, we still have the authority to sell, Mercury and Venus and Mars and Pluto and all. Well, Pluto's technically a satellite, but okay. So you see what I'm saying? So insurance claims affecting the property within the last 5 years, those kinds of things. So these are statutory disclosures that even the hypothetically exempt seller, there are very few exemptions to this to the requirement to use the TDS. Okay, and so agency disclosure obviously is a big deal, and statutorily required. It was a mistake in our old forms. We used to have the confirmation of agency in the purchase agreement was actually on paragraph number 17 towards the back of the form, and the district manager for the Department of Real Estate made a comment in a meeting that I was in. This was quite a few years ago now, where she said that we've been doing it wrong all this time. We've agents were never filling it out. And so, why? Because we buried it back on paragraph number 17. So that's why today it's on paragraph number 2 of your purchase agreement, because we want to make sure that confirmation occurs. Remember, so you have a duty to disclose the concept of agency. That's my agency disclosure form that we talked about earlier. But then you must confirm agency, because at that point, now we know whether we're going to be single agency or dual agency. And so we have to make that disclosure in a timely manner, and that's at the purchase agreement. Right. Okay. So important stuff. What other big thing in here? Acting against the broker's advice. So I threw that in there only because, again, it's a class on disclosures, but this is a pretty good form. This is created by the California Association of Realtors. Page 1 is all the instructions. Page 2 is I told you to make a completely or partially or partially non-contingent offer, and so I told you not to do that, but it's come to our attention that you're going to do it, and so we want to protect ourselves, and that is that if you continue forward with this, then you're acting against our advice. And so we want to make sure that we're very clear to the parties that we told you to do something, you chose to take a different path. I want to be on record to say that I told you not to do that. Okay, so bunch of our statutory disclosures. So let's talk about my Form AD. Again, that's my disclosure regarding real estate agency relationship. I think we spent quite a bit of time on that. I don't think, unless anybody has a question about it, I'm not going to flip back to it again. That's Civil Code 2079.13. We have the EPA. So, interestingly enough, the EPA regulation, and again, this is Title 40 regulation, is pre-1978 housing. It is not a law necessarily. It's a regulation, but it's an EPA regulation. So remember, regulation has the full force and effect of law, but they want to be able to change it at will. They don't want to have to get legislative approval to do that. And we see that with the commissioner's regulations and rules and things like that. So, so this is going to be my Form LPD, which I find frequently done incorrectly, by the way. Let's take a look at that one, because this is a good one. So here's my lead-based paint and lead-based paint hazards. Again, this was updated in 12/21, because if you recall, at around that time, we changed the rules on the requirement of how to deal with them. And so specifically here, we had the renovation rule, right? And that was that contractors, the new rule requires that contractors and maintenance professionals working in pre-78 housing, whatever that's going to look like, that their employees be trained, they follow protective works practice standards, and again, it's going to apply to activities affecting more than 6 square feet of lead-based paint in a room, right? Or more than 20 square feet of lead-based paint on the exterior. So we need to have it professionally done. The seller needs to have it professionally done. And this started back in October of 10. So this is 13 years ago. And we've updated our form, pretty quickly after that. So and they give you the link to the website, which is kind of cool. So this is the part I find most frequently missed, and that is the disclosure. So, so let me ask you a question, and some of you on this call today are brokers. So, let me ask you the question. Paragraph number 1, should anything go in here? And so my question is, we, the seller, have no knowledge of lead-based paint and/or lead-based paint hazard in the housing other than the following. So shouldn't the seller be putting in NA? There is nothing, right? Nothing else, okay? Nothing noted, okay? We have no reports or records pertaining to lead-based paint, et cetera, other than the following, which previously or as an attachment to this addendum had been provided to the buyer or tenant. And so again, nothing noted, not applicable, NA, whatever, but I never see these filled in. And so they're blank. So does that mean that they didn't apply, or does that mean that the seller just skipped over them? Okay, so again, watch out for that when you're doing your transaction. Make sure that you are completing your transaction. If for sales only, buyer has 10 days unless otherwise agreed. So they can waive this right, even though it's a statutory right, or they can minimize it to 1 day or something like that. Okay, so then again, the seller or the housing provider, because remember, this is also going to the top of the page. This is also applies to sales, leases, or rentals. So short and long-term rentals. Right. And so we're going to have either the seller or the housing provider. Housing provider would be the property manager or something along that lines. I think they probably should have added the RPO, the rental property owner, in there. And then on page 2, again, so page 1 belonged to the seller. Page 2 belongs to the agents and the buyer, and the buyer is really just going to affirm that they've gotten the lead-based paint booklet, etc. Now remember, because this rule also applies in leases, when's the last time that you did a lease? Now, usually we use a natural hazard disclosure company in a sales transaction, and they provide the environmental hazards for us. But in a lease transaction, there is no such application. So are you making sure that those environmental hazards statements, the booklet, the 6-part booklet, is being provided to the tenant of the property? So again, it's going to say that you gave it to them. They're going to say they just signed it, even though they did not receive it. So when I go back into here, and I'm going to look for my lease template, I'm going to pull up my lease template. Notice right here, I have an environmental packet. Can you see that? Yes, you can. So here's my environmental packet. It goes out on all my leases. And so number one, the residential environmental hazards booklet required by law. So it's required by law for sales and for leases. And so for sales, usually it's accomplished by the natural hazard provider. Make sure that the one that you're using actually provides it, because it's a law, and not all of them do. In fact, I'm going to tell you, most of them don't. So the one that we use does for sure accomplish the statutory objective. But again, on a rental, I don't have any such protection. We're not going to do a natural hazard disclosure. So I've got number one, I've got protect your family from lead in your home is number two. Number three is my home energy rating pamphlet. Number four is my earthquake guide to earthquake safety. Number five is my report, if any. And then number six is the guide, the total package signature. So you need to provide all of them. And I separated them out only because it's a big package to try to send. So what I'll normally do is I'll normally send the first five to the party, unless you can get it to fit within the electronic signature platform, because in most cases they're going to sign the sixth part of that. Is everybody good with that? Again, required by statute. You want to make sure that that's all being done. Okay, so back to my where was I? I was in my buyer seller listing template. I gotta remember what template was I in. Does anybody remember? Oh gosh darn. Where was I? Disclosures. Statutory and contractual. So again, these are all my, and I've pulled up the statutory disclosure checklist, which I should also show you that right now as well. So let's take a look at that. By the way, I mentioned the BMI form. This is my buyer material issue form. And so, I love this form. I really do. It's such a great form. But it says right down here, buyer's obligation to disclose material issues. So buyers agree to notify the broker in writing, here you go, of any material issue to the buyer, such as but not limited to buyer's request for information on or concerns regarding any issue of interest or importance to the buyer. So, we want the buyer to tell us specifically, and then we're going to define the scope of the broker's duty. Okay, so as I always say to you, when you define your duty, you limit your liability. So we're going to tell the buyer, this is what we're going to do for you, okay? But this is going to be the limit of our duty, all right? They don't use the word limit, they use the word scope. So if you read this and then don't make statements that are inconsistent with it, I think you can protect yourself in a lot of situations, not completely from harm, but again, these forms protect us. And so the buyer material issue form is a great form. Now, I did promise you that I would show you the sales disclosure chart. So this is the newest one that's out, and so statutorily or contractually required disclosures. And again, this is residential 1 to 4. So why is it a 1 to 4? It's a single family, a duplex, a triplex, a fourplex. It's because the civil code covers the innocent buyer or seller, which is defined, loosely by the statute. The assumption here is that when I get into 5s or greater, then I'm into commercial, and so you all be careful out there. You hear, that kind of thing. And so, but for purposes of protecting the innocent buyer and seller, we've got the civil code, and that's what gives us these disclosures. So again, statutorily or contractually required disclosures, and again, we're going to go deep into this on Thursday afternoon. I won't spend a lot of time on it, but these are all really great links. So TDS and the SPQ, how do they talk to each other? Obviously, they don't talk about the SPQA because that's a standard San Diego form. There's my AVID. There's my FERPTA. Whoops, it jumped. Okay, so my FERPTA, my qualified substitute, my buyer's affidavit, which will be for transactions that are less than $100,000. The NHD report, what does that do for us? Et cetera, et cetera, et cetera. So again, as I said, this is pretty lengthy, and it goes, a really great little dynamic breakdown here that, the sad truth of it is that most people don't even know that it exists. Okay. So any questions about any of that? Esperanza, welcome back. Boy, got lots of celebrities here today. Thank you all. I really appreciate you being here. Okay, so we already talked about the AVID. We went through this one. Lead-based paint we went through from the Zip Forms program, but I also wanted to show you the new laws. So, this is something that I did a talk on not that long ago. I know everybody likes to go watch Gov Hutchinson do new laws in the beginning of the year, and I really like Gov. And when I was chair of risk management, I had the pleasure of standing while he was sitting next to me. And so, if you can imagine the conversation that went back and forth between him and I during that meeting, he's certainly a very high level thinker in the legal field. And he got up, and I was really honored when he made the comment in front of the entire forum, and he said, "It's really nice to have a lawyer up here who understands, the laws and the practical side of our business." I was surprised they didn't make me like the chair of risk management for life, but anyway, it was such a kind comment of his. But he does the new laws, so everybody goes to see Gov, and I think you really should go to see Gov. He's really good at what he does. But all kinds of stuff in here. And again, I'll send you all this. Send me an email. I'll send it all to you. I noticed now that drug offense is no longer disqualifying to get your real estate license. So, it's like, oh, okay, I guess along with the other changes in California. So lots of really good stuff in here. And again, in fact, when I get down to the very bottom is where we talk about TDS and related disclosures are set on the date. I did a talk about that recently, but then there's another one that applies directly to us. Where was it? I'm always looking for the ones. Oh, here we go. So the requirement for implicit bias training for obtaining a broker or salesperson's license is postponed until 2024. You might remember that it was supposed to take effect on January 1 of 2023, but we kicked it up stream. But for renewing a license, it's still the operative date. But anyway, so enough of that. What else do I have? Oh yeah, okay. I have more stuff to show you, but let's fly through this here pretty quick. So the EPA, we talked about that. TDS, one of my favorite documents, the real estate transfer disclosure statement. And then again, that is Civil Code 1102.3. I have yet in my career to see the TDS filled out properly. Okay, so now I say that, and I know I'm going to probably upset some people, but it's just the truth I just never seen it completed properly. And so for those of you that were in my college level classes, and there are a couple of you here that were in those classes, I can tell you that that some things were added since then. So, for example, we have a third feature here under substituted disclosures. Before we had the first two, but they really rarely ever applied in a real estate transaction. But so we had to add, the legislative body added the third one, and so the law now says that if the seller doesn't check one of the three boxes, then the TDS is considered to be defective. So those are really powerful words, right? So the seller needs to check one of those. CAR came out with a really good Q&A explaining it. Again, I'll send it to you if you want. Send me an email. But page one, again, as I said earlier, belongs to the seller. They rarely know how to fill it out. Your job is to advise and counsel. Page two, same thing. I see my defects at the bottom of page one, where are there, to the best of you or the seller's knowledge, any of the above that are not an operating condition, yes or no? If it's not, one of those boxes is not checked, I'm sending it back, and I'm going to still give it to the buyer, but I'm going to ask the seller's agent if they wanted to have the seller complete the TDS or not, because I know that I'm loading my buyer up with a potential lawsuit. Same thing for the top of page two, but then I get down into C, paragraph number C, which I've never seen filled out correctly. 90% of the time, the seller just draws a line down through no. Everything is no. That means that that tells me the agent did not spend the time going over the form with the seller, because there's no way you can answer no to all these things. CC&Rs or other deed restrictions or obligations. So like my house in Del Mar, I cannot build a 16-story high rise. There's a restriction against it. If not just the view blockage, it wouldn't make sense in a residential neighborhood, right? So you can't answer no to that in almost any situation. So a lot of these things, that the seller just assumes, I've got the perfect house, nothing's wrong with it. It really is not the question. The question is, are you, the seller, aware of any of the following? And if they're not, they're not. Okay, so again, no harm for the person that says, I've never lived in it, I don't know anything about it, I inherited it as part of a trust. In which case they may have an exemption, but where's the harm in them saying, I just don't know? I mean, and the answer is, I don't know. Okay, so and then some of my disclosures, by the way. So here's my smoke detector. We'll talk about that a little bit later. We have a separate form, but you don't need it if you're using the current TDS form. And so that's the smoke detector. Then there's my water heater tank bracing. So again, you've made the disclosure in the TDS, so there's no obligation to do an additional disclosure. Up here, we have our window security bars, water conserving plumbing fixtures. Property doesn't apply to properties after 2017, that kind of thing. So we've got a lot of things that we have duplicate forms for. So for the TCs out there, please stop sending me forms that are covered in the contract. And I'm saying that with love and affection, of course, because some of you today are TCs, and so you see that it's already in the TDS. We don't need a separate disclosure. And so I don't mean to hurt anybody's feelings when I say we're not going to provide it, because we've already done that in the seller's disclosure. Okay, everybody good with that? I just want to cover that really quick. That's my TDS, one of my favorite documents. Again, as I said earlier, I've never seen it completed properly. The AVID, we've already talked about the AVID. That's the agent's visual inspection disclosure. I remember the district manager for the Department of Real Estate. I was in a meeting with her, and I remember her saying about the AVID that it's the one thing that we ask you to do. It's like, I don't know about that. I think we ask you to do more things. But listen, when Veronica talks, I'm listening. Okay, and she says it's the one thing, that she's telling me how important that is. And so Civil Code 2079 requires it. So, interestingly enough, let's pull that one up really quick, because there's an interesting misconception in the form. So let's take a look at something. Here's my AVID. Okay, so I'm gonna pull up the AVID. So here's a misunderstanding. I'm gonna go down to page 3, okay, because that's where the action is. So in this little box right here where it says this disclosure is based on a what? Reasonably competent, diligent visual inspection, reasonably and normally accepted. Oh, is again and again, Easton. You keep hearing the Easton case, right? So the firm who performed the inspection, but then down here it says signature of associate licensee or broker who performed the inspection. So what the Department of Real Estate says is, yeah, okay, so the seller's agent did the inspection, but then they bring the disclosure back up to the office, and the team lead signs it. And so in the immortal words of the district manager, we think that's fraud. Listen, when they say fraud, that's a big 4-letter word, right? I mean, it's like run, don't walk, okay? Because when they say fraud, that means you intended to deceive somebody. And so in this case, you signed the form intending to deceive people that you actually did the inspection yourself, when in fact it was one of your agents that did the inspection, one of your teammates that did the inspection. So even in that Lake Forest transaction that I did, I had sat with a seller for 3.5 hours. We did all of the disclosures. If I tell you everything was a complete package, one of our brokers was with us. He went around the property and did the AVID. He did the AVID. His name appeared on the AVID. He signed the AVID. Okay, so both of us under the same broker, Linda, right? And so completed the requirement to have one, but I didn't necessarily do it myself, but I clearly did not sign it as if I did. Is everybody okay with that? The AVID is a very powerful document, folks. And so I get these back all the time where, people will say, door sticks, just needs a little oil, or, again, water stain noted in the northeast corner of bedroom number 2, or one of my favorites was minor settling crack noted, and of course you never want to qualify that. You never want to, do an adverb or anything that describes it. Remember, you disclose, you don't diagnose. So these are my favorite terms, right? Disclose, don't diagnose. You don't want to be telling people what you think the cause of the problem is. You don't want, all you want to do is what you visually observe. Remember the Easton case? Whatever you read, whatever the visual inspection of the reasonably accessible areas, reasonably normally accessible areas of the property, the visual inspection. Is everybody good with that? Very, very important concept. Don't go outside of your lane, okay? FHDS, which is my fire hardening defensible space disclosure, it's the law. Let's just pull it up because I want to at least show it to you, but I can tell you that the FHDS, I actually like the form. And I remember in our meeting, I asked Gov about it, and I said, so how many times are we going to change this form? And it's like, we're changing legislation, right? We're doing that, but this is actually a great form. And people call me on this all the time, and I always ask them, did you read the form? Did you look at paragraph number 1? Because paragraph number 1 tells you whether or not you need to use the form, right? So paragraph number 1A, home fire hardening. And so they're going to be in home fire hardening, there are going to be 4 requirements, right? First of all, property is a 1 to 4, so covered by civil code. Okay. If the seller is required to complete a TDS, number 2. Number 3, it's in a high or very high fire hazard severity zone. And then number 4, the improvements were constructed before 2010. So after 2010, I don't need to have paragraph number 1A apply, right? So then I get into B, which is my defensible space compliance. And in this case, we're only going to have 3, and they come from the previous paragraph. So properties of 1 to 4, sellers required to complete a TDS, and the property is located in a high or very high fire. So it doesn't mention year built, right? So in that case, then, so it won't matter if any of these conditions are not met, then paragraph 3 doesn't have to be completed. Okay, so here's paragraph number 2. I always ask the seller, eave, soffit, roof ventilation. They go, what's that? And I go, I don't know, right? I'm not a contractor. I'm not a construction expert. And as much as I'd like to think that I know what those things are, it's kind of like my stem wall, right? Where the agent said, stem wall looks fine to me. We weren't even looking at the stem wall. Obviously didn't know what a stem wall was. Okay. All right. So great little website, readyforwildfire.org. You can actually look up properties by their addresses. So yes or no. Paragraph number 3 is my defensible space. Again, if it's in a high or very high fire severity, then, and again, depending on the natural hazard disclosure company that you're using, the new law requires them to make the disclosure for you, not to check the boxes. So the transaction we just closed in Malibu, it said AB 38 is voluntary. You don't have to complete the form. And so, of course, the seller chose not to complete the form. Okay, so we have an additional form called the DSTD DT, and that's the defensible space decision tree, and that's down here at the bottom. And I think this is just the best. You get down here, and I wish it was more interactive. I wish it was more dynamic. In other words, if you check the box that says yes, then it should fill in that part of the form. If because we have the capability of doing that. But now we're putting this burden back on the natural hazard companies, and we're doing that. CAR is doing that because it's such a confusing piece of legislation for our real estate agents. So again, step by step. If yes, then move on to the next one. If no, stop here. That kind of thing. Okay, so I like the form. It's a mess. Okay, and again, Gov said the same thing. He said, yeah, we're kind of trying to get that fixed. And so, and again, because the legislative intent was there to do good, but unfortunately, they created more confusion than they had before. We had one of our brokers, I wish they hadn't, but they contacted the fire marshal about coming out and look at a property that very clearly showed that it was in the fire zone. And the marshal got out there and said it's not in the zone. And the buyer's broker, one of our brokers, said, well, I looked at the map, and the marshal said, well, you're looking at the wrong map. We're looking at the 2008 version. You're probably looking at the 1990 version. And so it's like, well, we didn't know, right? But it's those little things, splitting hairs. But the 2008 version, it wasn't in the zone, and so we didn't have any way of knowing that. We're not supposed to be doing that anyway, right? We're not supposed to be going and pulling permits and doing stuff like that. So again, fire hardening defensible space. It's a 2-hour class when I give it. A lot of material in there, but it includes defensible space compliance, home fire hardening, and that's going to be Civil Code 1102.6. There's Civil Code 1102 again. Remember, talking about disclosures, right? 1102 to protect the consumer, the innocent buyer and seller, residential 1 to 4. So we have the CMD, which is my carbon monoxide detector. We've already seen that we don't need it. It's if you're using the current version of the TDS. Also, Civil Code 1102.6, smoke detector statement of compliance. That's going to be health and safety code, a couple of them actually. It's included on page 2 of the current TDS. The water heater bracing statement of compliance, same thing. It's also included on page 2 of the TDS, so we don't need to do it again. Water conserving fixtures compliance, that's going to be Civil Codes 1101.4 and 5. There is no CAR form NHD, and I wanted to talk about that. Why? We don't have it anymore. We used to have the NHD form in the library, but we took it out. And interestingly enough, specifically the reason that we took it out was because nobody was using it. I hate to say that, the fact that nobody is using a form. So why did they take that out? Well, the reality of it was that you can't see that. So the reality of it was, Holly, where are you? Where did it go? Here we go. So the reality of it was that nobody was using it. They literally they clock the number of times that these forms are used in a transaction, and they just realized nobody was doing it. So so they kicked it off and they said, okay, fine. You're all using third parties to do this. Hopefully you're using the right one. One of the reasons why CAR combined with a natural hazard disclosure company was because we want you to use somebody, and hopefully somebody has got insurance. But here, this is just an example of one that I asked this particular company to do one for me. But you can see that they made up a property and all that kind of stuff. But look at my zones. So remember, we have 2 earthquake, 2 fire, 2 flood. Okay, so 2 flood. This one's not in either of the flood zones, so everything's fine. But it is in the very high fire hazard severity zone, and so that's going to have a yes box next to it. And then over here, AB 38 disclosure form is voluntary, so it's not necessarily required, but they looked up the local jurisdiction's determination. Okay, you see what I'm saying? So again, this is that disclosure form where the seller signs it, and then the agents sign it. And so where's my language? They took the language completely out now, which is really good. Again, the legislative body put these together. The seller has an obligation to sign. They make the disclosure. Please don't have your buyer signing it before the seller does. Anytime you sign under a blank, there's the potential for somebody to change things above your signature. So the potential for fraud, right? So seller signs it, and then the seller's agent signs it, right? And then normally we have a third party. Unless you go to the statute and print the form, you wouldn't have the first box checked. It'll have the second box. It'll have the name of the company, and then it'll have additional information. The buyer then signs it. And notice there's no place for the buyer's agent to sign it. The reason is because the buyer's agent is not required by statute to sign it. The only requirement on the buyer's agent is to deliver it to the buyer. So very, very important. And then also in here and closer down towards the bottom is the environmental. Here I got right to it. So here's my earthquake risk disclosure chart, and then my above that I've got my here's my energy rating that we talked about earlier. And then there's my home fire hardening AB 38. Where is my environmental hazards? Here we go. He says with confidence, but he's not finding it right away. So should have been there. It's here someplace. I'll spend all day looking for it, and I don't want to do that. So, okay. So that being said, let me get up because we're going to have to round this one out here. And we're not close. Where did I go? Here we go. Okay, so no CAR form, natural hazard disclosure statement. Again, it's Civil Code 1103.7. No seismic hazard. That's included in the natural hazard disclosure. Special flood area, no form for that. It's in the natural hazard disclosure. State responsibility area, no disclosure for that. Look at all the statutes. Very high fire hazard severity zone. We don't have a form for that. There's no form, CAR form for airport in the vicinity, which is a statutory disclosure. And that's Civil Code 1103.4. Area of potential flooding. There is no CAR form for that. There's several codes that apply to that. We don't, again, 2 fire, 2 earthquake, 2 fire, 2 flood, and so we don't have a form for that. There is a CAR form for tenants, by the way, and so it's called the tenant flood hazard disclosure. And so if you're doing leases, then you really should be aware of this. Let me pull that. I never remember where I put it. Where did it go? Here we go. So I'm going to go to the tenant flood hazard disclosure because we do have a form for that. And I want to show you this because remember, it's required obviously for tenants. There it is right there. Okay, so the TFHD. But if I look at the form, so when we fill out this form, when the owner of the property, the RPO we call them, or the housing provider, fills out the form, we're always checking the box that says that it's in the zone, right? So because the default language says it's not in the zone. And so as I've said to you many times, that if you tell them it's in the zone and it's not in the zone, there's really no lawsuit, right? No cause of action. But if you tell them it's not in the zone and it is in the zone, then they're coming after you. Okay, so by default, I tell everybody it's in the flood hazard zone, right? But the beautiful thing is this, and it's not like I'm lying to them, but here's a really good website where you can go, type in the address, takes you to the San Diego website, and we always provide the form to the tenant, and just as a matter of principle. Okay, so let me see here. So anybody have any questions about that? Okay, all right, back to the PowerPoint. So there's no earthquake fault zone, obviously. Wasn't that interesting during the hurricane that we had that a 5.1 earthquake occurred up, where was it? Santa Clarita, I think. Fortunately, no injuries resulted from it. But again, that's a couple of civil codes on that, including 1103, right? No CAR form on common interest development documents, but that is a statutory disclosure. We're talking about all the statutory disclosures, okay, most of which are done for you. So, this is something I'm going to tell you again, don't worry about it. But common interest development, that's going to be Civil Code 4525, okay? And so it's in your purchase agreement. You need to know it's there, and it's a statutory requirement. There's no requirement that the seller pay for the documentation. The buyer can pay for it, but we want it to happen. Okay, so notice or actual knowledge of release of illegal controlled substance. So we have the methamphetamine contamination notice. That's the CAR form, MCN. Obviously, a couple health and safety codes. Why do we have to disclose that? Well, because it goes boom. Okay, so meth gets into a property, and it's incredibly toxic, incredibly caustic, and explosive. Okay, so if it's not cleaned properly, then we need to do something to make sure that it is. Okay, so flood disaster insurance requirements. Again, this is a federal law. Gas and hazardous liquid transmission pipeline. We fought this one, and the reason we fought it was because we didn't want the bad guys to know where the transmission lines were. How would you like to know that there's an 8-foot pipe running down underneath Rosecrans in Point Loma? You'd never drive down the road again, right? But we had to do it. The Civil Code required it. The legislative body came up with this about 15 years ago. Death on the property in the last 3 years. Again, that's 1710. Megan's Law disclosure is 2079. Again, that's us. Anytime you see 2079, it's us. Notice of special tax and or assessments. So my Melrose, a bunch of civil codes on that. Remember, it's a statutory disclosure, which means until the seller discloses the existence of Melrose in writing, buyer signing off on it, there is no the buyer has the right to rescind the contract. And so our natural hazard disclosure company discloses it, but that's why we order it before the transaction comes together, so we can give it to the buyer, and we have all these statutory disclosures done up front. I'm intrigued today why I'm working, we have a lot of transactions going on, but in a lot of them, the transaction coordinators, and again, I'm just throwing this out because I'd be kind of curious to hear, but the transaction coordinators will give them all the disclosures, the buyer's TCs, the disclosures, but then they don't give them back to us for 17 days. So are they doing that because they think the contract says that? Understanding that they were given the disclosures, so the time period is already run, right? But I've got one right now where it's gone, 2 weeks. And so it's like, okay, well, I gave them to you before the transaction, so I really don't care because I can document that I did it. But at the end of the day, I guess I don't understand the rationale behind holding them ransom. It doesn't change anything. In the old days, real estate agents would hang on to the escrow instructions and thinking that they could delay the buyer's ability to get out of the transaction, which was clearly not the case. And so now our contract says everybody's going to return them within 5. We change them to 1, but because we think you don't need a whole lot of time to review them. So ordinance again with no I. We talked about this when we went through the sellers, exempt TDS, 1102.17. Code of Civil Procedure 731A, again, also Civil Code 1102.15. So let's talk about contractual disclosures. There aren't quite as many of those, but remember, with my statutory disclosures, I have rescission rights, put the parties back in the position that they were in at the time of contract. But in my contractual disclosure, it's one that's required by contract, but it's determined by the relationship between the parties, right? So what are they? They contain cancellation rights. So rescission rights go to statute, cancellation rights go to contract. Rescission rights, there's no fight, right? Because it's a statutory, out. But with a contract right, a cancellation right, we can fight about that, right? So the buyer comes back and says, I'm not buying the property. Why not? Because based on, paragraph number 14, the buyer's, or paragraph number 12, rather, the buyer's investigation of the property. And so, I always ask the other side, I always ask the other agency, so what right are you calling on? And they say, well, we didn't like we have, first of all, we have the ability to get out of the transaction for 17 days for no reason. And it's like, that's not true, right? Remember, we discussed this earlier, material fact affecting the value and desirability of the property, right? So give me a material fact. And 9 times out of 10, they're speechless, and they can't seem to figure it out. But the bottom line is, it has to be a material fact. And so we can argue over whether it was a material fact or not. So like the light bulbs aren't working in the kitchen is not a material fact, unless it's an electrical problem in the house. But, real estate agents got to get out of that language that says I got a 17-day free peek. There's no such thing as a 17-day free peek. It just sounds really cool. Okay. All right. So cancellation rights, maybe an opportunity for the party to exit the contract without penalty, maybe. Okay. All right. So CAR form SPQ. I love the SPQ. It is an awesome form. Let's take a look at it just really quick. Obviously, we're not going to have enough time to go through it, but it just always amazes me. I've got somebody asked me the other day, do you really need 2 hours? I say sometimes I need more than 2 hours. Where's my seller property questionnaire? Come on, help me out here. There it is. Good. Oh, way down at the bottom. How did it get down there? Okay, so here's my SPQ form. Again, please note the revision date up here at the top. Make sure you're using the current form. Okay, so again, it says not a substitute for the TDS. All right, so I want you to remember this. You put down the SPQ, I'm sorry, you put down the TDS. Next to it, you put the SPQ. Next to that, you put the SPQA. They flow one to the other. So that the SPQ explains the TDS. The SPQA explains the local ramifications of the disclosures, things like that. So it's not a substitute. It's used in addition to the TDS. If they're exempt, then the seller should still complete an exempt seller disclosure form, or they can use this form instead. Why? Because down here at the bottom, the questions that are going to be asked are the statutory or contractually required or related. And this is my list that we saw earlier when we saw the exempt seller disclosure. So again, all these questions are designed around, are you the seller aware of any of the following? And then we go through all of this stuff. So I think, again, what a great job. I like the form. It came out of San Diego's Risk Management Committee. The form originally in San Diego was called the SAD form, which was the seller's additional disclosures. CAR liked it so much, they said, wow, we got to create a statewide form. And they did a great job, created a great statewide form. And then we at San Diego said, well, that's okay, fine, but there's a lot, you made a great general form for the state of California, but we have stuff specific to San Diego. And so we created the SPQA. So it was the addendum to this one. And again, I had an attorney call me the other day and say, I'm defending a broker. I'm defending the broker, and they did not use the SPQA. And so before I had a chance to say anything, they said, I know it's a standard of care, standard of practice in San Diego County. And I said, I don't know what to tell you, counselor. I would have used the form, but you need to be making sure. I don't care if you're in North County or South County or East County, but you need to be using the standard form, and that's the SPQA. So I know people are territorial about, I'm a member of North County, whatever. I was president of North County in 2001. So, but I'm going to tell you, you need to use the form that is the standard form in San Diego County, and that's going to be this form here. So this is the SPQ. So let's take a look at the, because I want to look at my SPQA, which of course came up towards the top of the queue. He says with confidence, Linda, help me out. Where is it? We were looking at the SPQ. I need the SPQA. Okay, I'm going to show you a shortcut. All right, so not there. So we're going to go back over to here. We're going to go here, and I'm going to type in SPQA, and there it is. It pulls it right up for me. So again, this is the standard form in San Diego County, and notice that a lot of it there's nothing to do. However, it's still going to be quite a bit. What? Maria, is if seller is exempt to fill out the TDS, are they also exempt to do the SPQ? And so the answer is yes and no. If they are TDS exempt, remember, it just means they don't have to use the TDS. But if they are TDS exempt, then they should use the ESD, which is the exempt seller disclosure. But if you recall just a second ago, when we were looking at the SPQ form, it says right at the top that that the seller should complete the TDS. If not the TDS, then they can complete this part of the form. They may use this form instead, and that again is going to be right here, paragraph number 6, which are my statutory disclosures. Okay, so they could use, thank you, Maria, great question. They could use this form still. They just aren't going to be held contractually to do it as they would with the SPQ. Okay, so great question. Thank you. On the addendum, you can see there's not much to do. There's a lot of paragraphs in here that, we just said, okay, that's fine. We're going to move on. The SPQ paragraph 5, 6, 7. Okay, we're going to ask for documents. 8, we're going to have a couple things we're going to ask for, right? And again, this is 6 pages of this, but some of these things, as I go through them, I see that we are trying to unpeel the onion, as we say, to get more questions answered that, again, the TDS does not ask. And so we've got, questions 10, 11, and 10 and 11, we don't need to comment on it because, CAR did a great job. They did everything that they needed. We didn't see anything relevant just to San Diego County. We're not just looking for work, right? Because again, we're asking the seller to complete another 6 pages. So we take that load seriously. So thank you, Maria. Thank you. I appreciate your question. I really do. So that's my SPQA. Flying right along, we've got the FERPTA. I'm not going to bring that one forward. The Foreign Investment Real Property Tax Act, or we have the qualified substitute form. We have the SPQA. We just talked about that one. The above are the hottest items in your disclosure list. I mean, they are real important documents to be sure to use. Again, there's no requirement for the seller to fill out a FERPTA. It's just that if they don't, then the buyer is required to withhold a certain amount of the proceeds. So again, under Fed, they have to hold 15%. Under the state, 3 1/3% of the sales price, or 9 1/3% of the net profit of the property. They're required to withhold that money if the seller's not going to provide the FERPTA. So I always tell people in closing here, excuse me, do your advisories, do your warnings, make sure you do that. So does it fall under a disclosure? Well, I don't want them to be able to say I didn't tell them that there are cyber crimes going on. I don't want them to say that you didn't tell me about wire fraud. You didn't give me the local area disclosures, which, by the way, the poster child of San Diego that I get in almost all of my meetings up on the board. Here's the LAD being shown as an example of what local associations should do for their members. Statewide buyer and seller advisory, there's a reason that it's as lengthy as it is, because we didn't want to make it part of the contract. The MCA form, at more today than ever, is one of the most important forms you're going to have done in your transaction. It says, I don't know anything about market going up, down. I'm clueless about that. I tell people all the time, I do trial work as an expert on market conditions, but I do have a crystal ball, but the batteries are low. And so I say, I really can't tell you what's going to happen, but I can tell you, in my professional opinion, what has happened. Okay, but I can't tell you what's going to happen. I mean, you put that piece together yourself. Water conserving plumbing fixtures, environmental hazards disclosures. And so I want to thank you. Anybody have any other questions? Our discussion today was all about disclosures, again, from the 30,000 foot level. We're going to drill into it on Thursday afternoon, but But we do have a new YouTube website. I like to make sure everybody knows about that. So get your QR code reader ready. If you got one on your phone, probably. So let's take a look. So there's the QR code. So I'll give you a second to take a picture of that. By the way, I did that myself a couple of months ago now. I learned how to do QR codes because I just really got tired of typing things in. You can also type in at Burke Real Estate Consultants Inc. Or we have a bit.ly link. And again, my RPA class was approved for 5 hours of continuing education credit. So I actually had to create a separate part on our website so that you could see the forms before you signed up for the class. That's a DRE requirement. So this is the reason why we did all this stuff. So bit.ly/real-estate-ed. And again, case is important. Please remember to like and subscribe. So liking just makes me feel good. I don't get paid for it. Subscribe is going to notify you of updates when I load them. So later on this evening, I will load the 2 from today up onto the YouTube website. And if you have subscribed to it, it sends you a notice when you log in the next time. It doesn't email you, but it lets you know. So it's not intrusive. Anything else you want us to talk about? education@sdar.com. You can send the email to them, copy me. You can send the email to me, copy them, whatever you would like. Let us know. I know that we're looking at 2024 already and revamping a lot of the classes that we're giving. My hat is off to SDAR. We're known as the Education Association. I was known as the Education President. I'm a big believer that education will set you free. So I do have an email address if you want to send me an email. Again, I'll send you copies of all the things that I used today for research. I spent a couple of days on this. I'm more than happy to give that to you. If you want to get on the newsletter, if you're not on it already, send me a request. Just send me an email, say, would you please put me on your newsletter? Or just send me a hi, how are you doing? I'll respond with my signature line, which has a button for you to push to get to the newsletter to subscribe, and then you get the direct link to all the classes. You don't see any more of that, classes sold out thing, because I want you in the class. All right, so I'm going to make sure you get in there. So those are included in the newsletter. Plus, on my email signature line is also a link for the webinar, the YouTube webinars. Okay, so again, just realizing I have the YouTube link also on the newsletter. So lots of paths. It's like it's what do they say in Alice in Wonderland? If you don't know where you're going, all paths will lead you there. The good news is that you have resources available to you, and I want to make sure that you're aware of that. So anyway, if there aren't any other questions, I want to thank you all for being here today. It is 4 o'clock. I've outstayed my welcome. But again, I look forward to seeing you on Thursday. TDS, SPQ, SPQA, AVID in the morning, statutory versus contractual disclosures in the afternoon. I thank you all for being here. And Holly, thank you so much. And I did better this time, right? Rather than this morning where I kept messing. Oh my God, I tell you, there's so much going on. So anyway, thank you, Holly. I appreciate you. So thank you all from my hometown of Del Mar. I look forward to seeing you around the track. Take care, everybody. Have a wonderful evening, and I wish you success. Bye-bye for now.